All right, welcome everyone to our mock law school class covering the topic of immigration law. We're super excited to have you all on the call. We welcome you to put it on speaker view, and that way you'll be better able to see Professor Barreto, who will be taking over. So Professor Barreto is our professor and our director of the New American Legal Clinic. She teaches our immigration class, which is an elective course. And she also is a law professor for our first year students teaching our legal methods class. And we're excited to have her on this call. She's been with the law school for 3 years. And prior to that, she was in private practice in specializing in immigration law. And she also worked for Kids in Need of Defense, which is a nonprofit organization called KIND. So she has her entire background is in immigration law, and I'm excited to turn it over to her. Professor Barreto, thank you for being with us.
Hi, everybody. Good afternoon. Thanks for spending your lunch hour with us. I'm really excited to see that so many of you are investing the time in yourselves and to learn more about law school and more about immigration law. It's great that you're taking advantage of these free resources. And as Diane mentioned, we're always happy to answer questions, learn more about you and about your interests and about how we can help guide your journey. Just a quick addition to that background, I'm born and raised in the Central Valley. I love the Central Valley. I went to UC Merced. I was the first class at University of California, Merced, and then returned to Fresno Clovis to attend San Joaquin College of Law. I graduated at UC Merced with high honors, so I had the opportunity to go to different law schools, but San Joaquin was my first choice because I think it's such a great resource in the Valley, and I really wanted to remain in a small environment where I knew I would get the specialized attention that I was hoping for. And so I've been licensed now for 7 years, and the entire time I've practiced immigration law. Prior to that, I also clerked in immigration law. So I would say that in total, I have about 10 years experience in immigration law. So feel free to type questions in the chat. Diane and Francisco will try to help me monitor the chat. You can also unmute yourselves and ask questions. This will go pretty quick because I only have an hour, but I hope that you really enjoy it and know that if you have follow-up questions, please don't hesitate to reach out. Okay, so I have a PowerPoint that I would like to share with you. And this will be part of what we're covering today. So I'm going to just go ahead and get started. The New American Legal Clinic is one of 2 clinics at San Joaquin College of Law. We also have the Bren Clinic, which is a clinic directed by attorney Jody Howard, and it specializes in the needs of students in special education and advocating for special needs students and for them to get the resources that they need while they're in school. The New American Legal Clinic, of course, focuses on immigration law. We've been a department within San Joaquin College of Law since 2006, so going on 10 years. And it's headed by our dean, Jan Pearson, and she oversees all of the departments at San Joaquin College of Law. But the New American Legal Clinic was actually founded by Dean Atkinson, and I am the director. We have 4 people on staff. We have a staff attorney, Jaspreet Kaur Howdagi, 2 client coordinators, Kenya Garcia and Araceli Mota, who are also DOJ accredited. And then Miriam Ochoa is our administrative coordinator. And then we also employ various student interns and volunteers. In any given semester, we can have up to 10. Right now, we're at about 8 for the summer. And so when you are a student at the New American Legal Clinic, you get to work as if you are an associate attorney. We give you cases, we give you training, you have office hours. And so it's a really unique experience that you won't find anywhere else in law school with the clinic. And so you get to work directly alongside me, and it's really nice to have that hands-on experience with students. What do we do? What do students help with? These are just a part of what we do. We primarily focus on citizenship cases, but we've been growing a lot recently and focusing on more complex cases, including family-based immigration, U visa, VAWA, removal defense, and community outreach, know your rights. And we're going to kind of break these down slide by slide, and it will correlate with your reading, which hopefully you all had a chance to review. Also really important to know that even if you are not a part of the New American Legal Clinic, when you begin your journey at San Joaquin College of Law, you can refer friends, family, and community members. All of our services are completely free of charge. And so it's a really great resource in the community. I used to be a private attorney at a local law firm. And for example, a citizenship case can range approximately between $1,000 and $2,500. So by a client coming and using the services at the New American Legal Clinic, it's like giving them a coupon for $1,000 to $2,500 off, depending on the complexity of their case. All right, so let's get right into it. This first slide is just kind of what are the three branches of government? Who can tell me, does anybody know what the three main branches of government are? And feel free to unmute yourself, even if you just know one.
Executive, judicial, and legislative.
Perfect. Awesome. That was easy. Thank you, Amvika. So the legislative branch is in charge of making laws. The executive branch enforces laws, and it's headed by, of course, the President of the United States. And then the judicial branch interprets the laws. And so this, of course, is all of our different court systems that we are going to get a little more familiar with in just a minute here. So the two main bodies that are involved in immigration are the Department of Homeland Security, which is DHS, and then it is headed by Secretary Alejandro Mayorkas, which is a Biden appointee. And just some, these are not all, just some of the agencies that fall under the Department of Homeland Security is CBP, which is Customs and Border Patrol, ICE, which is Immigration Enforcement, USCIS, which is U.S. Citizenship and Immigration Services, and OPLA, which is the body of attorneys who defends DHS essentially. USCIS is the affirmative, it's the customer service based arm of the immigration process. This is where we file applications when we are not filing a defensive remedy. The other major branch that plays a role in immigration is DOJ. And DOJ is the Department of Justice, and it is headed by the Attorney General, Merrick Garland, also a political appointee. And under the DOJ, some of the agencies are EOIR, which is the agency that I am most familiar with. It's the Executive Office of Immigration Review. And then also other agencies, which I'm sure you've heard of before, which are FBI and DEA, which we know are investigative agencies, law enforcement agencies. So does anybody have any idea or any opinion as to why immigration, especially in recent years, has become such a hot topic and has become so controversial? And just feel free to kind of give your opinion. I mean, kind of what do you think? Why has this really come to light in the last, say, 5 years or so?
Linda, you have somebody in chat saying security and another person saying competitive labor market.
Okay, so those are some reasons why. And I really like Daniela's comment of it's political now. And the thing is that it's always been political. And why has it always been political? Because what do we think? There's these three branches of government, right? We've already discussed those. Which branch of government do you think DHS and DOJ fall under?
Executive.
Executive. Both of them fall under the executive branch. And so that is crazy, right? Because you have two agencies which are heavily involved in immigration, and the head of each of those agencies is a political appointee. And of course, many political appointees, including both of these people, are confirmed by Congress, but I mean, it's actually not very common for Congress not to confirm a political appointee, because usually the president will not put forth a political appointee that they don't think can win the nomination of Congress. And so essentially you have the president, and we saw this in the last administration and we're seeing it now, sort of make decisions that are impacting the lives of others based on the political appointees that they choose. And so that's why it has become such a hot topic recently, because there have been two political parties in the last two administrations. Of course, we just came out of a Republican administration, and now we're in a Democratic one, who have very different views on immigration and who speak very passionately about their views. And so when we have issues as far as, okay, well, now I have filed a case or I'm in court and I want to appeal that case. Now I didn't like the decision that I got for that case. So say that what you filed was a naturalization case. You filed a case for your client to become a US citizen, and you did not receive a favorable decision on that. Your naturalization case was denied. In that case, you would then appeal the case to the AAO. And the AAO is the Administrative Appeals Agency for USCIS. Notice, we are not in court. I'm appealing to yet another agency. Now, if I am in court, if I'm already in immigration proceedings, means that I would be in the EOIR, then I would appeal my unfavorable decision to the BIA. The BIA is the Board of Immigration Appeals. This functions more like a court, yet they almost never hear oral argument. Everything is almost always done by a briefing schedule. And so again, you still really don't get your day in court. When you are at EOIR, at immigration court, you do get to go before the judge, and there is opposing counsel who is a member of OPLA, who works for DHS. And then you have your immigration judge, who is part of the DOJ under Attorney General Merrick Garland. So now what? So let's pretend that I appeal my case to the AAO and they still deny my case. What do you think then the remedy is? Any idea? If I'm not happy with my decision from first USCIS and then AAO, what do you think would occur then? What can I do?
Are you able to go to the EOIR?
So that would make most sense, right? I should be able then to take my case before an immigration judge.
How about you, man?
But that's actually not the case. What ends up happening is you end up filing, finally, you're in the judicial side of the court, and you can appeal that to a federal district court. In Fresno, we are part of the 5th Federal District Court. And so that means that if USCIS issues a decision, I don't like it, I appeal it to the AAO, I still don't like it, I would then file an appeal with the Federal District Court. So now I'm in a totally separate part of the government. I'm no longer in the executive branch of the government, finally. And why do I say finally? Because now it's no longer a political issue. Federal district courts also have judges that are appointed by the president, but these are judges that have been appointed by many presidents, not only by the current president. Does that make sense to everybody?
Good question. How
Yeah.
do you know whether to initiate immigration proceedings through USCIS or EOIR?
So if you are filing something that's an affirmative remedy, I have not been notified through what's called a notice to appear. I have not been notified through a notice to appear that the government is moving to initiate deportation against me. then I file what's called an affirmative remedy, and I file that through USCIS. Nobody's trying to deport me, but I'm trying to gain some sort of immigration benefit. So I file that through immigration at USCIS. Now, if the government, say I'm arrested by ICE on my way to work, and the government now says, we're trying to deport you. We have reason to believe that you're here unlawfully. We want to deport you. That case, the notice to appear, is filed with immigration court, with EOIR, and now I have to defend myself, and that's why we call it removal defense. We are defending you against removal, and we are trying to set forth a remedy that can help you legally stay in the United States. Okay, so now we are, we know that what to do, how to appeal a final decision from USCIS, but now we're at EOIR. The immigration judge denies my case. I appeal that case to the Board of Immigration Appeals. And now I still don't like that decision. Now what should I do? Any ideas? What do you guys think would be the appropriate remedy?
I'm just guessing, but would it still go to the federal district courts too?
So kind of, but not really. It does finally go to the judicial branch. Yay. But we are actually going to go to a different higher federal court. This is the federal circuit courts. Now, bonus points to somebody who knows how many circuit courts we have in the United States, or even just what circuit California is in.
Is it the Ninth Circuit?
We are the Ninth Circuit. So that means that if I appeal a decision, I get to go before the Ninth Circuit Court of Federal Appeals. And there are different circuit courts throughout the United States, depending on where you live. I do believe it's 13. Good job, Ashley. Thank you for that. And so the circuit courts then will decide whether or not the BIA applied the law correctly at that point. Okay, but now I don't like my decision from the federal circuit court either. What should I do?
Do you just continue to go up to like a higher court?
And what's the highest court in the United States?
The Supreme Court?
Supreme
Supreme
Court.
Court. So we get to go to the Supreme Court. We have to file what's called a writ. And the writ isn't guaranteed because, as you are, I'm sure, aware, the Supreme Court doesn't take every case that it's petitioned on. They only want to decide novel issues or issues that have some sort of constitutional element to them. And so the chances of your case actually getting before the Supreme Court are very low. And so many times cases die at federal circuit court because that's all we can do, right? If the Supreme Court is not going to accept their writ, then we can no longer appeal that decision. It's a final decision by law. Kaylee, you have a question?
I was wondering what happens like while they're waiting for it. Do they end up getting deported, or how does that work?
So there's a few different things that you can do. You can do what's called a stay of removal. You can file that stay with federal circuit courts and say, I have a final order of deportation, but I'm asking you to not enforce it until you decide on my appeal. I want a decision on my appeal yet, and so I'm asking for a stay of removal. And those are generally granted if it is an appealable issue. And then you can also ask for a stay of removal with ICE. So ICE, which is the branch of government out of DHS who is responsible for executing the removals, they can hear your case as to why they should grant you a little more time. And I've had cases with successful stays with ICE where they have compelling humanitarian factors, such as, considerable health issues or maybe mitigating family factors. Anvika, I think you have a question?
Yeah, are there courts that come in between the federal circuit courts and SCOTUS, or does it go directly from the federal circuit court to SCOTUS?
It would go directly from the federal circuit court to the Supreme Court.
Okay.
There's no other remedy in between. Okay, Gabriella, you have a question?
Yes, I do. So generally, when you file a writ of certiorari, is that correct? The correct pronunciation for SCOTUS to hear it, doesn't it have to have a plausible constitutional crisis such as like Roe v. Wade? How does immigration play into a constitutional case, and how does the Supreme Court decide if they want to hear that case?
So anytime that a writ comes before the Supreme Court, it's voted on by all justices to see whether or not they believe that the case has a constitutional question. There are many constitutional questions in immigration law. One can be, for example, an unlawful search and seizure. So if I was detained and I wasn't given, my rights, and for whatever reason my car was unlawfully searched, that would be a constitutional issue, because as you may know, the Fourth Amendment of the Constitution is against unlawful search and seizure. And so that could just be just one example of how constitutional law can come into place and cross paths with immigration law. And all people, not just citizens, not just residents, all people within the United States are protected by the Constitution. And so if any of your constitutional rights are violated, then you may have a case before the Supreme Court.
Professor Barreto, somebody asked, how often do cases go to the Supreme Court?
So I don't have the exact percentage, but it really depends, because some clients, particularly in immigration law, by the time your case gets to the Supreme Court, it's likely you've been fighting 5-10 years. And if they are held in detention during this entirety of their proceedings, because not all immigrants are eligible for bond or for release while their case is pending, they get fatigued and they're like, at this point, I'd rather just accept the deportation and leave. And so it really just depends on the issue and on the case and on the attorney who's representing the client, because sometimes, like Gabriela said, we may just have to tell them, I don't think that you have a constitutional issue here. There's really no question for the Supreme Court to decide. Therefore, we can submit a writ, but the fact, like whether or not it's actually going to be accepted, maybe are slim to none. Okay, so now that we know what areas of government we're in, who are the players, let's talk about what is actually the difference between a citizen and a resident. Now, a lot of times we'll see things on social media where there will be some terrible news story about, an immigrant, whether it's positive or negative, but usually it has some sort of bad factor, as in, someone's getting deported or an immigrant committed a crime or something to that effect. And you will see people saying things like, well, if they would just become citizens, they wouldn't have this problem. Okay, but it's not that easy. It's not that easy, and people don't understand that in order to become a citizen, more often than not, you first need to be a resident. Now, there are some very narrow exceptions to the residency requirement, which we'll briefly discuss. But there are worlds of differences between what a citizen is and what a resident is. Now, we know that the Constitution has an amendment that says all people who are born within the United States derive citizenship at birth. You're born magically a US citizen. It's important to note, though, that that's not the case in every country in the world. For example, two prominent countries are Japan and Australia. If I go to Japan and I'm vacationing there with my family and I'm having a great time, and my baby is born in Japan, if I, for whatever reason, go into labor early, my baby is not a Japanese citizen, but that would not be the case if my baby were born in the United States. If I was a Japanese woman traveling to the United States to come to Disneyland or Disney World and I go into labor early, if my baby is born here, my baby would be an American citizen. So not all laws in all countries are created equally as far as derivative citizenship. And so it's important to know the difference between what is a citizen and what is a resident. Important things to note about residents is that they cannot vote, they cannot serve on a jury, They cannot remain outside of the United States for more than 6 months without special permission, which is called the reentry permit. They can be deported even for very old convictions. And they have to renew their green card, what we call in Spanish, amica, every 10 years. And the current filing fee is $540. Every time that they renew their green card, they have to get their biometrics, fingerprints done, so that we as a government can ensure that this person should still be eligible for residency. So what about citizens? Well, I can become a citizen after I have been a resident for 5 years or 3 years if I am married to a US citizen. I have to be able to complete the English competency reading and writing understanding. But there are some exemptions. So if your client is 50 years old and has been a resident for at least 20 years, he or she can choose to take the citizenship examination, which we call naturalization, to complete the naturalization interview and test in their preferred language. Same goes if your client is 55 years old and has been a resident for 15 years, or if they qualify for a medical exemption. So there is a disability waiver that can be completed by the applicant's physician. The civics examination is 100 questions, and those questions are asked in sets of 10. If your client answers the first 6 questions correctly, they've passed the test. We don't know which 10 questions they're going to be asked, so they have to study and hopefully know all of them. If your client fails the civics examination, they will have another opportunity to apply under the same application, but they will have to come back for an interview at a later date. There's also an exemption for the civics questions. If your client is 65 years old and has been at least 20 years a resident, they can take a modified simplified exam, which is only 20 questions long. They are still only asked 10, they still pass with 6, but instead of having to memorize the 100 questions, they only have to memorize 20.
Professor Barreto, sorry to
Yep.
interrupt.
Go ahead.
We had a couple of questions. One is, can the person see the exam and study prior to the exam? And the other is, what does a question look like?
So the answer to the first question is all of the materials for the civics and English examinations can be found for free. And there's also study materials at uscis.gov. And you should give your client as much anticipation to study as possible. It's always a good idea to start early. There are some easy questions and some difficult questions. So for example, one easy question could be, who is the current president of the United States? A more difficult question would be, how long is the term of a senator? Who knows that without Googling?
6 years.
6 years. So those of us who are brushed up on our US history or constitutional law may know that, but you know, I don't know all of those facts off the top of my head. You have to look them up a lot of the time. So it could also be a question like, name 3 of the original 13 colonies. I don't know. I wonder how many of us would get the questions right? I mean, of course, I know them because I'm constantly studying them with my clients, but, you know, an average person just, you know, kind of out on the street may not know the answer to those questions. All right. And then there's also a good moral character requirement, which is sort of the way that immigration will try to decide who is worthy of becoming a citizen and if there are any disqualifying crimes. The statutory period is 5 years. So if your client even has something like a DUI within 5 years, they would not be eligible to apply for citizenship, not because the DUI is a disqualifying offense, but because the DUI occurred within 5 years prior to the application. There are some disqualifying offenses though, which would make a client deportable, and we don't have time to get into those all, but if you take my class, once you're a student, I'd be happy to talk to you more about them. And then there's a physical presence requirement and a continuous residence requirement too. Now, there is, like I said, the option of someone actually being a US citizen at birth, even when they were not born in the United States. That is done on Form N-600, and the Form N-600 kind of gives you two different options. One of them is that I was not born in the United States, but my parents became residents and then eventually citizens before I turned 18, while I was still a minor. Those requirements are based on the date of birth of the child and the physical presence requirements of the parents. They also look to see whether or not parents were married. If parents were not married, then they're looking into who had custody of that child. And then also if you are already in the United States as a resident, so the child is a resident, parents are now citizens, I, as a child resident, may have already derived citizenship from my parents because I'm legally in the United States and my parents have become citizens before I turned 18. Now, what's the difference? Why do I care? Because if I've already derived citizenship, I got it as operation of law through my parents, I don't need to apply for citizenship. I don't need to complete Form N-400. I don't need to become a naturalized citizen because I'm already a citizen. All I have to do is fill out this form and prove that I meet the eligibility requirements. Why is that important? Because, for example, we've had a client who had a disqualifying offense. He committed a crime which would make him otherwise ineligible for citizenship, so we could not pursue N-400. But after further investigation, it was clear that he was actually already a citizen because his parents were citizens while he was still a minor. Therefore, he didn't have to meet the 5-year residency requirement, the good moral character. He didn't have to take that English test or memorize those 100 questions. Do you understand the difference there? Okay, so great. We're talking about how to achieve the ultimate goal for immigration, to become a US citizen. That's the ultimate goal. That's the finish line for most immigrants. But I'm not a resident, and my parents were not citizens when I was born, or my parents never obtained citizenship while I was under 18. I have no status, right? This is what the media calls illegal immigrants, or what the Immigration and Nationality Act, which is the big body of law that that is over immigration law, calls aliens. We hear that word aliens in Immigration and Nationality Act. So I have no status. What can I do? Well, there's a few different options. The United States runs on a family-based immigration system. And the family-based immigration system gives classifications based on family relationships. And this was part of your reading, and you would have read that there are some different priority dates and different classifications, and there's limits to certain numbers of immigrants that can come in under certain categories. So if there is an immigrant who has no status and would like to achieve the next level of status, what would we as attorneys be trying to get for them? So I'm an immigrant, I have no status. What are we going to apply for?
Would it be LPR?
Yep, for residency. I'm applying for LPR, stands for Lawful Permanent Residency. How do you know that? Because I just told you that you cannot get citizenship unless you're a resident or unless your parents were citizens either when you were a minor or at the time of your birth. So I cannot go from 0 to 100. I don't get to just jump the line and say, okay, you have no status. Sure, let's apply for citizenship. No, we have to apply for that residency status. Now, the technical term is lawful permanent residency. So this is a permanent status, and they can remain indefinitely in the United States with the ability to work. However, lawful permanent residents can still be deported if they commit a disqualifying offense. Citizens can never be deported. So if you have a client who you help naturalize, who eventually obtains their citizenship, God forbid that that client commits murder, but if they do, then you don't have to worry about that client being deported because they are now a citizen. Residents don't have that same luxury afforded to them. So in order to even become a citizen, though, we have to become a resident first. So how can I become a resident? Well, one of the most common ways is through adjustment of status. And that's exactly what it sounds like. You're adjusting your status from no status to some status. There's different ways that this can be achieved. And it's usually afforded to people who have a legal entry. So they entered with some type of visa, some type of permission. Or if they have an unlawful entry, they had a petition that was started for them prior to April 30th of 2001. And this is codified in the INA, the Immigration and Nationality Act, under INA 245I. Or if they have a family member who has served or is currently serving in the US Armed Forces, they may have the option to apply for parole in place and eventually adjust their status that way. Now, those three ways mentioned are common ways. They're not the only ways, but they are very common, especially with family-based immigration. And those are all done within the United States. Those are all ways that they can become residents here in the US. But if your family member is outside of the US, you can also do what's called consular process with or without a waiver. And that waiver may be for issues, either crimes or inadmissibilities that the immigrant has that they need to overcome. Now, there's a key date of April 1, 1997, because prior to April 1, 1997, people could enter and exit the United States almost as many times as they wanted if they were never deported. But after April 1, 1997, there was a new law introduced through the IRA, I-I-R-I-A. And essentially that law said, if you exit after this time, then you will have what's called a bar. And that bar will come with a 10-year punishment that you have to serve outside of the United States before we will allow you to immigrate legally. And that's why it's with or without a waiver, because if your client needs a waiver for multiple unlawful entries, then you're going to have to help them with that process. Again, these are kind of more of a deep dive, but just a general overview is what we're doing today of what processes are available. The next way that someone can become a resident is through the Violence Against Women Act, VAWA. Now, the Violence Against Women Act is not just for women, it could be for men as well, or any other gender identity. It's based on abuse from a US citizen or lawful permanent resident spouse, parent, or son or daughter. So I am a non-citizen, my spouse is a US citizen, and he or she is abusive to me. I may be eligible for VAWA. I am a non-citizen, my parent is a US citizen, I'm a child, I'm a minor, I'm 17, and I can possibly qualify for VAWA because my parent, who's a US citizen, is abusive to me. And then the last scenario is I am an adult, I'm 65 years old, and my daughter, who's 30 years old, is abusive to me. She's a US citizen. I can maybe apply for VAWA. This abuse may be verbal, physical, or psychological. It is not a requirement to report this to law enforcement. And why do you think that that's not a requirement? Any ideas about that?
Because people who don't usually have residency, who don't have residency, are usually not trustworthy of police.
That's one important reason, yes. Any other ideas?
If they were in an abusive situation, they may have not been able to report it.
Yes, similar as well for similar to what Camila said, that's another reason, the cycle of abuse. But also because not every type of abuse is against the law. What do I mean by that? I mean, my husband makes me sleep outside. He tells me I can only eat 500 calories a day. He gives me a $20 allowance per week. I think that many of us on the call would agree that that does constitute some sort of psychological abuse. But can I call the police and say that? They'd be like, okay, sorry about it. You know, they're not gonna come and arrest him for that. So you have to think outside the box and think about, just because you have not lived through those abusive situations, that doesn't mean that your clients haven't. And just because what you have a pre-formulated notion of what abuse looks like doesn't mean that there aren't other types of abuse. So immigration law will open up your eyes and just your senses to different kinds of situations that may qualify. If your abuser is a spouse, divorce is not required. But if your client has divorced the abuser, you have 2 years to file, but your client cannot remarry before VAWA is granted. So important that there is a time limit there if there was a divorce. Some inadmissibilities can be waived if they're tied to the abuse. So say that your client was arrested for domestic violence and she was convicted, but during your intake with her and during the process of application, it comes out that she was actually arrested and convicted for that because she was in a self-defense type situation and she didn't have an attorney who really understood her situation, and she was just afraid to be deported. So she took the plea because they told her that if she took the plea, she would get off on probation or something like that. And so if you can tie that conviction to the abuse, it can be waived without the need of a separate waiver. And again, VAWA is done as an adjustment. Your client would go from no status to residency within the United States without having to leave the country. The other type of remedy available is U visa. Unfortunately, U visa in itself is not residency. U visa is what's called a non-immigrant status. And the non-immigrant status means that I am allowing you to remain in the United States, but it's not permanent. Remember, we said lawful permanent resident. Non-immigrant visa is meant to be a temporary form of protection. The U visa is available for victims of violent crimes. There's also some derivatives that could fall into that U visa. It does require a certification from an investigative agency, which shows that the client cooperated with the investigation. You also have to file a waiver for I-192, and it is discretionary. So if your client was the victim of, say, rape, but she or he himself have their own issues, like they were deported before, or they themselves have some convictions on their record, they will need to file Form I-192, but it's discretionary. So if your client was the victim of a crime, but they themselves are committing crimes, deportation, USCIS may say, sorry, the balance is off here. So while we agree you were the victim of a crime, we also agree that you are not worthy of this U visa. Now, when U visa is granted, it's granted for a period of 4 years, and that client can apply for residency. Now we're back in residency world after 3 years of having that U visa. people love U visa because it's very, very forgiving. And it's a way for someone with no status and no family to adjust status eventually, to have a pathway to residency. But there's a huge backlog. They only grant 10,000 per year. That's all Congress has authorized. And the only way to get more is through an authorization of Congress. So right now, we do anticipate for someone who files a U visa today, we anticipate about a 12-year plus wait. I see you have a question, Anvika.
Yeah, so if you're going for a U visa and then applying for residency, would you be applying through the Violence Against Women Act?
No, U visa is its own separate entity, and usually people who qualify for, who choose to do the U visa path is because they don't qualify for VAWA. So remember, for VAWA, you have to have that qualifying relationship. Your abuser must be a citizen or resident, your spouse, your parent, or your son or daughter. For U visa, maybe I was held at gunpoint at the mall, and maybe the suspect was never even apprehended. I would still qualify for U visa.
And then is there a residency requirement for Violence Against Women Act residency applications?
What do you mean a requirement?
For, like, if you're applying for residency through the Violence Against Women Act, do you have to prove that you're physically in the United States for a certain period of time before then?
No. You
Okay.
can apply at any time that you become eligible, but the abuse must have occurred while in the United States, while you were living with your abuser. Esmeralda, you have a question?
Yeah, yeah, I have a question. So to kind of clarify, so like say, I know there's like a time limit, the 2 years, like after divorce to apply. Is that for both of them? So say like there was a person who experienced like say abuse in a relationship and they left that relationship. Is there a time limit for like how long they could try to see if they qualify for either one, because for the women's one, I'm not sure if I made.
Yeah, I understand your question. They have to prove that the abuse occurred during the time that they were living with their abuser. If the abuse occurred 5 years ago, but I can prove that at that time that the abuse occurred, I was living with my abuser, even if I'm not yet divorced, then I can still apply. But if I get divorced, I only have 2 years to apply because now the marriage has legally ended. Does that answer your question?
Yes.
Thank you. Gabriela, you have a question?
Yes, so you talked briefly about the VAWA and how the abuser has to be in the United States. But what if a woman is seeking asylum in the United States and her abuser lives in the country that she's coming from? Are there protections and ways to expedite? Okay, I guess that's the follow-up that I was wondering, just because that's something that I was interested in, making sure that women have those protections, and how can we protect them and expedite the process since the immigration process takes such a long time.
Absolutely. And yeah, we'll get to that question as well. So asylum is another affirmative remedy, and it can also be used defensively. But it's a way that people who come to the United States, if they were fleeing their abuser or fleeing some other type of threat, can apply for status within the United States. It's available to those who are already in the USA. So I cannot apply for asylum from my home country. I have to be already in the United States. You can apply affirmatively, so you can apply with USCIS, or you can apply defensively, as in I'm in now deportation proceedings and I am raising asylum as a defense. But not everyone qualifies for asylum. It's based on these 5 very important protected grounds: race, nationality, political opinion, religion, or membership in a particular social group, which we hear as PSG. Now, Gabriela's example might fall into that PSG. The PSG would be, I'm a woman, I'm a Mexican woman, let's just say she's from Mexico, Mexican women unable to leave abusive relationships. That would be the particular social group that this attorney formulates, and we have to show the judge that there is a pattern of women in this particular country, Mexico in this example, who are unable to leave their abusive relationships and where the government is unable or unwilling to protect them. So if Gabriela's client never reported the crime, that could be a hurdle. I mean, we've overcome it, but it could be a hurdle because the judge might say, okay, but how do I know that the government was unwilling or unable to protect you? And Gabriela might come up and say, well, because here's a history of hundreds of other women in this part of the country who have suffered the same thing. They did report, and eventually maybe some of them were even killed because law enforcement did nothing to protect them. So my client is likely to be in the similar situation. Camila, I think you have a question.
Yes, I was wondering if immigration law works hand in hand with international law for asylum.
Yes and no, not really within the United States. Usually it's sort of protected countries altogether that sort of have ideas as to who qualifies for asylum, but the United States is not forced to follow other countries' examples, as other countries are not forced to follow our examples. So yes, but not as much as you would think. Gabriela, you also have a question?
Yes, just to follow up to that, you said, for example, if I was the attorney representing a woman coming from a country where women might be afraid to stand up to their abusers or to report because law enforcement is unable to protect those women, then how would you be able to bring up those examples and prove that there's a pattern of abuse?
So we use what's called country conditions. And when you're a law student, you will have access to Westlaw and LexisNexis, which are two databases that house almost all judicial opinions and research. And so you research this and you find other court cases where this has been the case. You research the laws of other countries to see that, for example, maybe women don't have as many rights as they would in the United States. And you present a packet of country conditions. Okay, so the other thing that students in the New American Legal Clinic learn is removal defense, and we talked about this a little bit, and we said that this is for cases that are already in deportation proceedings, people that already have a hearing date. They already have to go before an immigration judge. Different types of remedies other than what we've already talked about could be cancellation of removal. This is a type of case. So this is for someone who has been in the United States for a minimum of 10 years, has no disqualifying crimes, is a person of good moral character, and can prove hardship on their qualifying relatives. Qualifying relatives are U.S. citizen children under age 21 or lawful permanent resident children under age 21, lawful permanent resident or U.S. citizen parents. So I'm a non-citizen. I find myself in deportation proceedings. If I can prove that I take care of my elderly mother or father or both, and they are citizens or residents and they depend on me, then I can include their hardship, or also the hardship of my spouse. So if my spouse is a resident or citizen and I can prove that my deportation would result in hardship to them, then I could potentially qualify for cancellation of removal, assuming that I meet the other eligibility requirements. And then of course, we talked about asylum already and how we can present that case. There's also special immigrant juvenile status. This is for what we hear, all of these children coming across the United States with no parents. And in order to help a child become eligible for special immigrant juvenile status, as their attorney, you need to show that they're unable to reunify with one or both parents. And that reunification inability needs to be based on abuse, abandonment, or neglect. And as their attorney, you also have to show that it's not in their best interest to return to their country of origin. This is a direct pathway to residency, but there is quite a backlog. And so your client could be waiting a couple of years before they would be eligible for residency, even if you get their special immigrant juvenile status approved. There's also motions to terminate. So the government is not perfect and they often get things wrong. If the government has served your client with a notice to appear, but that notice to appear is incorrect or deficient in some way, and you can prove that to the judge, you can move to terminate the case because the government cannot be held to their burden of proof. Basically, they can't prove what they're alleging, and therefore the judge has to terminate the case. And then the other thing that we do is know your rights. So as I mentioned at the start of today's lecture, all people that are within the United States are protected by the US Constitution. So we know that we have the right to remain silent. Even if I am pulled over by a government official working for DHS, I'm not required to answer any questions. I do not have to give my name. I do not have to say where I'm from. I do not have to give my date of birth. Instead, we should advise our clients to answer, am I free to go? Am I under arrest? Am I free to go? Am I under arrest? If I'm then arrested, then I know I have the right to remain silent. You also have the right to fight your case in court. So although the government will not provide an attorney the way that they do in criminal cases. So you know that if you're arrested and accused of, say, DUI, that's an example we've used today during class, you can be appointed a public defender if you don't have the funds to hire a private attorney. That's not the case in immigration court. They are not afforded attorneys. So if your client or a client is unable to secure representation, they do still have to move forward and serve as their own attorney in their proceedings. Some clients are not eligible to fight their case in court if they're subject to reinstatement. Reinstatement means I've already been deported before, I had my day in court, and then somehow I'm back in the United States unlawfully. The government can reinstate my prior order of removal. And then there's expedited removal, which means that I can be removed quickly at the border if, say, I enter the United States and I show false documents. I do not have the right to see a judge. The CBP officer who's inspecting me can automatically right then and there issue a deportation order. I have the right to an attorney. Of course, we already said not at government expense. Remind clients that carrying foreign identification could mean that they are now unable to defend themselves, because the government can only charge you with what they can prove. So if the government cannot prove that I'm from Sweden, they have no documents to prove, no birth certificate, no passport, no foreign identification, then sorry, not my problem. So a lot of clients will carry foreign identification on them. And by doing that, you're helping the government do their job, because now they can already prove that you're from Sweden. Okay, and then post-conviction relief, that means that even if your client has been convicted of a crime, they may have the right to go back and retroactively fight that case if there was a deficiency in their conviction. And that's a more complex term, but again, you need to know that it exists. And essentially what I want you to take away from that is that even if a client has already been convicted of a crime, it's not the end of the story. We may be able to go back to criminal court and correct that conviction somehow. I believe that we're right on time, but I would like to leave time for questions or comments. And again, share with you that I'm really excited that you all were able to join today's call and stay on. As Diane mentioned, I also teach legal methods, which is a first-year writing course, totally different from this course, but I would maybe potentially have some of you in class for writing. And I do see some questions coming in. So Diane, if you want to field those questions, I'm happy to stay on a few extra minutes.
Yeah, why don't we take any questions first to Professor Barreto, and then that are related to this topic, and then myself and Francisco Rosas will be happy to help answer questions. But Kaylee, go ahead. You have your hand raised?
Yeah, I was just wondering your opinion because on the reading it was talking about how like each year the president determines the number about how many people are able to come over. Do you think that it would be easier if there was just one set number, or do you think that it's good switching every year?
I think it does depend on, I mean, and now this is just my personal opinion, it does depend on the conditions of the world at a whole. You know, sometimes there are more refugee crises, like for example, we saw a few years ago, and there still continues to be a big crisis in Syria and the Middle East. And so I think at that point, it does become the responsibility of more developed countries, including the United States, to help ease that load and take in more refugees. So I think that it is helpful that it's flexible. But even though sometimes the cap is high, if USCIS is not processing these applications in a timely manner, it may not make a difference. Like, for example, the prior administration really lowered the cap to the lowest almost it had ever been. And even then, they were not meeting the cap because processing delays and et cetera, et cetera.
Thank you, Linda. You also have a hand raised by Esmeralda Luna.
Yeah, so my question is kind of like about like the class. Like the class that you teach. So what exactly like what else is the classes like what else is like kind of covered in this class?
So we go in through more in depth into each of these topics and learn how to prepare an actual case. So you would have clients of your own that you work on each of these types of cases that we've discussed, where you are what we call a student advocate. So you work right alongside me and the rest of my team preparing these files. And then we do a deeper dive, of course. So one class section focuses only on U visa. I mean, today was just introducing you to different types of remedies available, but it's nowhere near the depth that we go through in class.
Awesome. Thank you, Professor Barreto. You also have a question from Camila Flores.
Hi. So one of the facts that really struck me that I didn't know about was if you're carrying foreign identification, you're actually helping law enforcement. I guess my question would be, I know that when people get stopped, they're usually asked for like a legal form of identification, and this is why people carry their foreign identification cards. What would they say in like this situation when they don't have like a legal form of identification?
So at least in California, everyone who's 18 years and older, regardless of immigration status, can obtain a driver's license under the law AB 60. So my recommendation is that they obtain a California driver's license, because a California driver's license doesn't indicate your place of birth.
Thank you.
You're welcome.
Great. Well, I don't see any more questions directly related to. Oh, okay, we got one more.
I have a question about the Department of Justice. At what point? I trying to remember how you said exactly their role in the immigration process. Could you just touch on that a little bit? I know you may have already touched on it earlier, but if you could.
Yeah, of course. Let me just go back to that slide really quickly. So the Department of Justice is headed by the Attorney General, who is Attorney General Merrick Garland at this time. And the immigration courts are housed under the Department of Justice, which means that all immigration judges are Department of Justice employees, which means that a political appointee, in this case, Attorney General Merrick Garland, is the boss of all of the immigration judges.
Awesome. Thank you, Professor Barreto. All right. Well, I am going to transition here. I know people have to return to work, and just thank Professor Barreto for being with us today. Thank you so much for this mock law school class. It was very interesting. And if you have any closing comments or remarks, Professor Barreto, and then we'll end the class, and then Francisco Rosas and I will stay on for any questions about the law school application or the law school in general.
Sure, yeah. I just also want to mention that we do offer intern and volunteer opportunities for people who are interested in coming at San Joaquin College of Law, but maybe are still finishing up their undergraduate degrees. And I've put my email in the chat if you are interested in the future learning more about the New American Legal Clinic, or if you have questions about law school, as I mentioned, I'm an SJCL alumna. I really enjoyed my experience. I passed the bar on my first attempt, and it has just been full circle for me to now work where I gained my law degree. And as Diane said, you know, there are just so many opportunities. I've had just an abundance of opportunities because of having a law license and a law degree. So if you have questions just about those things, I'm always happy to talk with you about that as well.
Awesome. Thank you so much, Professor
Okay.
Barreto.
Thank you.
Okay. Bye-bye.
Bye-bye.
All right. Is there anybody on our call that has questions specific to applying or the law school in general? And before we do, I just also want to introduce you to Francisco Rosas. He just turned on his camera. He is our Assistant Director of Admissions. He's my colleague, and we're both here to help answer any questions and remove any barriers for you as you're considering this incredible career path.
I've also gone ahead and just put some of the requirements up there in the chat in case anybody has some questions regarding those requirements. Kind of go over them, and then just maybe that will prompt a question. Oh, we got one here. Diane, what is the average LSAT score to get into San Joaquin College of Law?
Okay, great. So the LSAT is scored a 120 to a 180. And what we like to see at San Joaquin College of Law is a score of 150 or better. That is what's optimal to get into the law school. That being said, if you have a high GPA or if you have you know, excellent work history, you can also try to get in if your score is in the 140s. You know, a higher 140 is going to be better than a lower 140, but I would encourage you to still apply and see if you get in. But when you're taking your practice exams and you're preparing for the LSAT, try and take as many time practice tests as it takes until your score is hovering around a 150 or better. That's the score you want to at least shoot for.
Yeah, definitely. I can take this next one. States, if I want to apply for fall 2022, when would be the best time to take the LSAT? So we kind of recommend that you start studying a whole year in advance, right? You don't need that much time. Everyone is different. So it's kind of up to you, right? When you feel that you're ready, that you have enough practice exams underneath your belt. For this remaining year, we have one coming up in August, which I believe that it's already too late to register for that one. There's going to be another one in October, and then the final one is going to be in November for this year. So then in the following year, you also have some. If you go to lsac.org, and I'll put the website right now up here, you could also look at those dates, but usually they'll have one like in February, May, and then the final one that we usually accept is in June. So you have 3 times available to take the LSAT within an administrative year. Administrative year goes usually from June to July of the following year, right? You can only take it 3 times within that time period. So we suggest that you definitely take it before the June one. That way, in case if you don't have the number, the LSAT score that you wish to obtain, right, you still have some more available tests, 2 more available tests there to be able to take it again. So it just depends on when you feel that you've studied enough and you're ready to go.
Awesome. Thank you, Francisco. Esmeralda, you have your hand up. How can we help you?
Yeah, so I had a question like about the schedule. I know there was like a mention that there was like an AM and a PM schedule. What's the times for the classes?
Sure. So our evening program is 6:30 to 9:30. That's our evening program. So you take one class on Monday, one class Tuesday, a class on Wednesday and Thursday, 4 different classes that are in 3-hour blocks of time. And that's our evening program, 6:30 to 9:30. We also have day classes, and the day classes, they run in 1.5-hour blocks twice a week. So, and again, the classes are Monday through Thursday. So for instance, there'd be a class from 9:30 to 11. We would be happy to send you a sample schedule so that you can really visualize yourself as a student at San Joaquin College of Law. So just shoot us an email and we'll send you the schedule. Are there any more questions?
Can you guys hear me?
Yes.
Okay, this is Justo talking. So I had a question just about the Zoom meeting. I was only able to catch so much because I am at work. I'm still working, but I was listening to everything as much as I could. So is there any chance I can access this video unless you guys record it so I missed the main part I was interested in, which is becoming a resident, because I actually have a family member that is coming with a visa, a traveler visa, but we want to eventually get her to a resident to be able to work lawfully and stuff.
Yeah,
So-
thank you. Thank you for asking that. So we are going to make the recording available on demand for people. This was our series of mock law school classes that we've been offering throughout this past year to help people become more familiar with our professors, and we've been covering different topics. So this topic on immigration law by Professor Barreto is one that we will be sharing with you and making it available on demand. So thank you for asking that, and thank you so much everybody for attending this outstanding course taught by Professor Barreto.
Hopefully